Good evening. How's everybody doing? Great to be learning with you on a Monday, Yom Sheni. Let's light up the darkness. Who's in the house? Yehud in South Carolina, Bella in Florida, Melissa in Great Neck, Bill in Mid-Missouri, Joe in the Inland Empire, Nancy in North Carolina, Guy in Ohio, Sharon in New Jersey, Shandor in the Bronx, Jonathan in Southern California, Karen in Northern California, Marjorie in Georgia, Ella in Southern California, Frank in San Pedro, Ilanit in Silver Spring. Welcome, everybody. Our daf today is page 5 here in Tractate Sanhedrin, the 24th volume of the Talmud, continuing our discussion of Mishnah number 1 in chapter 1. The Mishnah was all about the composition of court, of a rabbinic court for various kinds of cases. Most cases require a panel of 3 judges. A capital case, death penalty case, requires a court of 23. The Great Sanhedrin for matters involving the nation, 71 judges. And there's a few kinds of cases here and there which don't fall into those categories. We pick this up at the very bottom of page 4b. The sages taught in a baraisa cases cases of monetary law are adjudicated by 3 judges. But if one, and now we're on page 5a, if one was a judge accepted as an expert for the public, then he may judge cases even as the lone judge. And Rav Nachman said, one such as I may judge cases of monetary law as the lone judge. And similarly, Rabbi Chiya said, one such as I may judge cases of monetary law as the lone judge. So presumably this would be a judge, a rabbi, who is so learned in monetary law that he's competent to judge on his own, and in addition of such sterling character that we wouldn't feel like, we want the protection of having 2 more judges on the panel. So this kind of a judge, a very, very prominent and learned rabbi, could judge cases of monetary law as a solo judge. Now, a dilemma was raised before the sages. What is the meaning of such as I in the statements of these 2 rabbis, Rav Nachman and Rabbi Chiya? Did they intend to say such as I in that I have studied and I have the skills to extrapolate and derive new rulings on the basis of earlier decisions, and have also received permission to judge as the lone judge? But accordingly, if one has not received permission to judge as the lone judge, then his judgment would not be a valid judgment in the absence of a panel of 3 judges? Or perhaps this is not the correct reading of these statements, and the law is that even though he did not receive permission to judge as a lone judge, because he is at this level of prominence and expertise, his judgment would nevertheless be a valid judgment. So the Gemara suggests, come in here a resolution to this dilemma from the following case. Mar Zutra, the son of Rav Nachman, once adjudicated a certain case, and he erred. He made a mistake in his ruling. Upon recognizing his error, he came before Rav Yosef to ask what he should do. And Rav Yosef said to him, if the litigants accepted you upon themselves as the lone judge, and they both agreed that they would accept your ruling, then you are not liable to pay restitution to the party who lost the case due to your erroneous ruling. But if they did not accept you on themselves, but were rather compelled to be judged before you, then you must go and pay restitution. And learn from it, that even in a case where one did not receive permission to judge as the lone judge, his ruling is a valid judgment. And the Gemara affirms, learn from it, that this is the case. And so the law on this particular question ended up like this from Shulchan Aruch. A judge accepted as an expert for the public, meaning one who has studied extensively, is experienced in judging cases, and has been found to be both knowledgeable and skilled, may adjudicate cases as the lone judge. Nowadays, however, There is no one who is accepted as an expert to the extent that he can compel litigants to accept him as the lone judge. So litigants can submit to his authority in the same way that litigants in an arbitration can submit to the authority of the arbitrator, but they can't be compelled to sit before a lone judge, though they could be compelled to sit before a panel of 3. Now, Rav says, one who wants to adjudicate a case and wants to be exempt from payment of restitution, if he errs in his judgment, must receive permission from the Exilarch to judge cases. So now we're talking about the community, the Jewish community in Bavel, in Babylonia, which was part of the Persian Empire at this time. And that Jewish community had a leader known as the Exilarch, sort of like the king in exile, as it were, descendants of the royal family. And they had a good relationship, in fact, with the kings of Persia. And so here he's saying that if you want to be exempt from having to make restitution, you make a mistake. So you have to be given permission to act as a lone judge. If you're talking about in the community in Bavel, then you would need to receive that permission from the Exilarch, the leader of the Jewish community in Bavel. And similarly, Shmuel says, in such a case, he must receive permission from the Exilarch, right? And in Hebrew, or I guess in Aramaic, the Reish Galusa, so the head of the community in exile, Reish Galusa. Now, since the Gemara mentioned the importance of a judge receiving authorization from the Exilarch, it now discusses the scope of this authority. It is obvious that from here to here, meaning relying on the permission granted by the Exilarch in Babylonia, in Bavel, in order to adjudicate cases within Bavel, and from there to there, relying on permission granted by the Nasi in Eretz Yisrael in order to adjudicate cases within Eretz Yisrael. The Nasi was the head of the Sanhedrin in Israel, the head of the Jewish community in Israel when it was under Roman authority during this period. So post the destruction of the temple, post having kings of Israel. So the Nasi is the leading authority, even though the actual political power is in the hands of some Roman governor. But the Nasi is the head of the Jewish community, and it would be the Nasi who would give permission to a judge to adjudicate cases on his own and not be held liable for making a mistake and have to make restitution for that mistake. So what they're saying is, in Eretz Yisrael, the Nasi gives permission to judges to judge cases by themselves. And in Bavel, the Exilarch gives permission to judges to judge as a lone judge and not have the risk of having to make restitution if he makes a mistake. And what they're going to ask is, can the Nasi appoint a judge to judge cases by himself in Bavel? And can the Exilarch, give permission to a judge to judge cases by himself in Eretz Yisrael? Does their authority, cross from one region to another? From there to there, relying on is effective. And it is also obvious that from here to there, relying on permission granted by the Exilarch to adjudicate cases within Eretz Yisrael, in the land of Israel, this is also effective, as the authority of the Exilarch is greater than that of the Nasi. Even though we think of the rabbinic community in Eretz Yisrael as being a little bit closer to the source and often carries a little bit more weight than the opinions of the rabbinic community in Bavel, in terms of authority, the Exilarch, the Reish Galusa in Bavel, has greater authority than the Nasi in Eretz Yisrael, is what we're learning now. And this is so since the Exilarch here in Bavel may be termed a scepter, i.e. a ruler with actual power of governance, and the Nasi there in Eretz Yisrael is only a staff, i.e. a legislator with limited power. And this is as it is taught in a Baraisa. The verse states, the scepter shall not depart from Judah, nor the ruler's staff from between his feet, until Shiloh comes. Genesis 49:10. Now, the term Shiloh is understood, or sometimes pronounced Shiloh, the term Shiloh is understood as a reference to Mashiach, to the Messiah, the coming of the Messiah. And therefore, the verse is interpreted as delineating the authority of Jewish rulers during the exile, before the Messiah comes. So the scepter shall not depart from Judah. These are the Exilarchs in Bavel, who are empowered by the government and consequently subjugate the Jewish people as a king would with his scepter. But the verse, nor the ruler's staff from between his feet, these are the grandchildren of Hillel the elder, who hold the position of Nasi and teach Torah in public, but do not have authority to actually enforce their judgments. So even though their wisdom and sort of Torah authority might be higher, their actual enforcement power is not as great as the power of the Exilarch. If one has permission from there, meaning from the Nasi in Eretz Yisrael, and wants to adjudicate cases here in Bavel, so what is the law? And the Gemara suggests, come in here, an incident that occurred. Rabbi Bar Chana adjudicated a case in Bavel, and he made a mistake. And he came before Rabbi Chiya to ask what he should do. And Rabbi Chiya said to him, if the litigants accepted you upon themselves, then you are not liable to pay restitution to the party who unjustly lost the case. But if not, go and pay. But Rabbi Bar Chana received permission from the Nasi in Eretz Yisrael. Therefore, learn from this incident that the permission from there in Eretz Yisrael to adjudicate cases here in Bavel is not effective. And the Gemara affirms, learn from it, that this is the case. Now the Gemara asks, and is this permission really not effective? But when Rabba Bar Rav Huna was involved in a dispute with the members of the house of the Exilarch, he said, it is not from you that I receive permission to judge cases. I receive permission from my father, my master, i.e. Rav Huna. And my father, my master, received permission from Rav. And Rav received it from Rabbi Chiya. And Rabbi Chiya received it from Rebbe, right? Rabbi Yehuda Nasi, who was the Nasi in Eretz Yisrael. Therefore, it seems that permission received in Eretz Yisrael is in fact effective in Bavel. And the Gemara rejects this proof. He was merely standing up to them with words alone, but there was no halachic validity to his statement. The Gemara asks, but since the permission to judge received in Eretz Yisrael is not effective in Bavel, why did Rabbi Bar Chana need to receive permission when he left Eretz Yisrael to go to Bavel? What was the value of that permission? And the Gemara answers, the permission is effective for the cities that stand on the borders of Bavel, which are not entirely in the jurisdiction of Bavel. So permission from Eretz Yisrael is effective in those border towns. New subject. What is the specific nature of this permission to act as a judge and therefore to judge cases alone? And the Gemara relates, when Rabbi Bar Chana descended to Bavel from Eretz Yisrael, his uncle Rabbi Chiya said to Rebbe, meaning Rabbi Yehuda Hanasi, my brother's son is descending to Bavel. May he teach people and issue rulings with regard to what is prohibited and what is permitted. And Rebbe said to him, he may teach. Rabbi Chiya then asked, may my brother's son, may my nephew, also adjudicate cases of monetary law and be absolved from payment if he errs? And Rebbe said to him, he may adjudicate. And Rabbi Chiya asked one more question. He said, may my nephew declare a firstborn animal permitted? And this means the male firstborn of a kosher animal may not be eaten, as it is supposed to be offered in the holy temple. Once the temple was destroyed, then what? We still have this requirement, but there's no way to offer it in the temple. So what do? We wait, we allow it to graze, no one can make use of it or gain from it, until it acquires a permanent blemish. That would make it unfit to be brought as an offering in the temple. Then you can give it to a Kohen, to a priest, and he may slaughter it and eat it, share it with whomever he wants. It doesn't only have to be eaten by priests, but it has to be given to a priest, and then if it has that blemish, so it's unfit for offering on the altar, it can be eaten. So this idea that a judge will, can look at a blemish on the animal and say, yes, that's a blemish that would disqualify the animal from being offered on the altar. So now you can give it to a Kohen and he can eat it. So Rabbi Chiya was asking Rebbe, may my brother's son, right, Rabba Bar Chana, may he declare such animals permitted for eating, meaning that may he recognize in them a blemish that would make them unfit for the altar. And Rebbe said, yes, he may declare such an animal permitted. So Rabbi Chiya asking, may his nephew, his brother's son, Rabba Bar Chana, issue rulings, may he teach and say what is permitted and what is not, may he issue rulings in court, and may he declare animals permitted by recognizing they have such a blemish. And the answer was yes in all three cases. A little time passed, and then Rav, who was also a nephew of Rabbi Chiya, was going to Bavel, leaving Eretz Yisrael and going to Bavel. So Rabbi Chiya went to Rebbe and said, my sister's son is descending to Bavel. It's a nephew, a slightly different relationship. So he said, my sister's son is descending to Bavel. May he teach people and issue rulings with regard to what is prohibited and what is permitted. And Rebbe said, yes, he may teach. And Rabbi Chiya said, may he also adjudicate cases of monetary law and be absolved from payment if he makes a mistake. And Rebbe said, yes, he may adjudicate. And Rabbi Chiya continued, and may he declare a firstborn animal permitted for eating, like it has a blemish that would make it unfit for the altar. And Rebbe said to him, no, he may not declare such an animal permitted. So Rav came up a little bit short, seemingly, in the estimation of Rebbe, as compared to his brother, his cousin, like his fellow nephew of Rabbi Chiya. Sounds like Rav came up a little bit short compared to Rabba Bar Chana. Or did he? Let's learn more about this incident. This incident raises several questions, which the Gemara asks in sequence. What is different concerning this sage, Rabba Bar Chana, that Rabbi Chiya called him my brother's son? And what is different concerning that sage, Rav, that Rabbi Chiya called him my sister's son? And if you would say that this was the situation, that Rabba Bar Chana was his brother's son and Rav was his sister's son, you'd be mistaken. Because doesn't the master say that Ivu, Rav's father, and Chana, the father of Rabba Bar Chana, and Shela and Marta and Rabbi Chiya were all sons of Abba Bar Acha Karsala from Kafre. So consequently, Rav was also Rabbi Chiya's brother's son. He could have said about both of them, my brother's son is going down to Bavel, may he adjudicate, etc. So why is it that if he was also the son of his brother, a different brother, why would Rabbi Chiya refer to Rabba Bar Chana as his brother's son and to Rav as his sister's son? So before we read this explanation, let's look at this chart. It's a little bit, I don't know if this is in focus enough for you to see it, but this is the family structure of Rabbi Chiya and Rabba Bar Chana and Rav. Yeah, and so you can kind of see it. And the bottom line is that Rabbi Abba had a first wife and a second wife. And by the first wife, he had these four sons, right? Ivu, Marta, Shela, and Chana. And then Chana, he had a son, Rabba, right? So Rabbi Abba, he had a grandson who was Rabba Bar Chana. Okay, and Rabbi Abba also had a grandson who was Rav, the great sage Rav. He was a grandson via Ivu, but he was also a grandson via Ima. And that's because Ivu, who was Rabbi Abba's son by his first wife, married his stepsister, Ima, who was the pre-existing daughter of this wife, the second wife of Rabbi Abba. So it's a little bit like, Greg married Marsha Brady. They're not blood relatives. He married his stepsister. And it wasn't like they grew up together either. The second wife came on the picture later and already had this daughter. but they ended up getting married. Okay, so the point being that Rabbi Chiya could have referred to Rav as the son of his brother, a different brother, or he could refer to him as the son of his sister. So the question is, why did he refer to him as my sister's son rather than say about him my brother's son? That's what we're exploring. So first the Gemara will sort of lay out how the family was related. Right? So, but doesn't the master say that Rav's father Ivu and Chana, the father of Rabbi Bar Chana, and Sheila and Marta and Rabbi Chiya were all sons, all brothers, right? And they were all brothers because they were all the sons of Abba Bar Acha Karsala from Kafre. So consequently, Rav would also be Rabbi Chiya's brother's son. And the Gemara answers, Rav was his brother's son, who was also his sister's son, as Rabbi Chiya's half-brother married Rabbi Chiya's half-sister, while Rabbi Bar Chana was his brother's son, who was not his sister's son. And therefore, he referred to Rav in a manner that emphasized the additional relationship. Or, if you wish, say instead that the reason that Rabbi Chiya called Rav his sister's son was a different reason. Now we're on page 5b. And it was due to Rav's extraordinary wisdom. As it is written, Proverbs 7:4, say to wisdom, you are my sister. Therefore, calling Rav my sister's son was an indication of his tremendous wisdom. It wasn't that Rav had any kind of a shortcoming compared to Rabbi Bar Chana. So why was it that Rebbe gave him all the power to declare what's pure and impure, to adjudicate cases, but not to say that an animal is permitted by recognizing that it has a blemish that would have prohibited as an offering on the altar? So the Gemara had related that Rabbi Chiya asked Rebbe, may Rav declare a firstborn animal permitted? And that Rebbe had said he may not declare such an animal permitted. So the Gemara asks, what is the reason that Rebbe denied him this permission? If we say that it was because Rav was not sufficiently wise and learned, but that is difficult, as we already said that he was exceedingly wise. So rather, it must be that it was because, although he was quite knowledgeable about the law, he was not an expert with regard to blemishes on animals, meaning that he lacked the practical expertise to apply the law to actual cases. Right? Wrong. The Gemara rejects this answer. But didn't Rav himself say, I apprenticed with a shepherd for 18 months in order to be able to know which blemish is a permanent blemish and which is a temporary blemish? Now remember, this is long after the temple was destroyed, right? So bringing offerings was completely off the table. But you still had the need of it to say, okay, here's a blemish that renders a firstborn animal permitted because it's the kind of blemish that would have prevented that animal from being brought as an offering when the temple was standing. This shows you the degree of dedication that Rav had to his studies, that in order to be able to perfectly identify such blemishes, he apprenticed himself to a shepherd for 18 months to really learn blemishes inside and out. So sounds like there's nobody more expert than Rav to render such rulings. So why would Rebbe say, no, he cannot render such rulings? Let's keep reading. Didn't Rav say, I apprenticed with a shepherd for 18 months in order to know which blemish is permanent and which is temporary? So evidently, he had a very high level of practical expertise in this matter. And the Gemara explains, rather, the reason Rebbe said he may not issue such rulings was in order to bestow honor upon Rabbi Bar Chana, his cousin. Rebbe wanted to ensure that Rabbi Bar Chana would be treated with respect. So he made sure that there was an area of halacha, of Jewish law, with regard to which the people would not be able to consult with Rav and would need to consult with Rabbi Bar Chana instead. Rav was so exceptional that once he went down, he was just going to become the head of everything. It was clear to Rebbe. So since he still wanted Rabbi Bar Chana to get some honor, maybe he left out one area where, okay, Rav, you focus on everything else and let Rabbi Bar Chana give these rulings so that he will still, have a certain degree of respect in the eyes of the people in Bavel. That's one explanation. And if you wish, say instead, the reason that Rebbe said no to Rav for issuing rulings about blemishes is due to this fact itself. Since Rav was such a great expert with regard to blemishes, he would permit blemishes that average people do not know about. And as a result, they would erroneously say, with regard to a different blemish, in a case like this, Rav declared the animal permitted, and in this way, they would come to erroneously permit an animal with a temporary blemish, believing it to be identical to the blemish that Rav had declared permitted because of his incredibly nuanced and subtle knowledge. And it was due to this concern that Rav was denied the authority to declare firstborn animals permitted on the basis of a blemish. He was too much of an expert, and people wouldn't be able to understand all the little nuances that he was spotting. Now, and they would make mistakes because of it. Now, with regard to the permission granted to Rabbi Bar Chana and Rav, the Gemara had related that Rabbi Chiya asked Rebbe, may he teach people and issue rulings concerning what is prohibited and what is permitted? And Rebbe responded, he may teach. And so about both of them, Rebbe said they may teach. So the Gemara asks, if he had studied and mastered the relevant laws, why do I need him to receive permission? The need for formal authority is understandable when it comes to serving on a court to judge cases of monetary law, but any knowledgeable person should be qualified to answer questions about ritual law. If he's an expert in ritual law, then he may say what's permitted and what's prohibited within ritual law. So why would he need to get permission from Rebbe to be such a teacher? And the Gemara explains the need for such permission is due to an incident that took place. As it is taught in a Baraisa, Rebbe once went to a certain place and he saw people there kneading dough while they were in a state of tumah, of ritual impurity. And they believed that nevertheless the dough remained ritually pure, tahor. So Rebbe said to them, for what reason are you kneading your dough while you know that you are tameh, you are in a state of ritual impurity? And they said to him, well, a certain Torah scholar came here and taught us that water from swamps, me betzaim in Aramaic, water from swamps, me betzaim, does not render food susceptible to contract tumah. Remember that like a pile of wheat cannot become tameh until it comes into contact with one of the 7 liquids that render food susceptible to tumah. If it's dry and has never come into contact with liquid, it cannot become tameh. So one of those 7 liquids is water. And once it comes into contact with water, then it can become tameh. But these people thought that water from a swamp is by definition not water. It's swamp water, and that's different than water. And they thought that because this Torah scholar had told them that me betzaim, water from swamps, does not render food susceptible to a tumah. But in reality, what that Torah scholar had said was that water of eggs, me beitzim, does not render food susceptible to tumah. Not me betzaim, but me beitzim. Sounds similar if you're talking fast, me beitzim, right? So they heard swamp water when he had said egg water. What's egg water? Just the white of an egg. That looked, or the albumin that looks a little bit watery. I know it's much thicker, obviously. But what he was saying to them is that the transparent albumin of an egg, that is not one of the 7 liquids and does not render produce susceptible to tumah, but they misheard him and thought that he had said swamp water. And the residents of that same place made a second mistake. With regard to this, it was taught in a Mishna, Para 8:10, that the waters of the Karamian River and the waters of the Piga River are not fit for mixing with the ashes of the red heifer to create the water of purification that would allow somebody, to become purified after coming into contact with a corpse, so that he could, go through the 7-day purification and then enter the temple. But you need it to be sprinkled with the waters of purification, which are these water mixed with the ashes of the red heifer. And that water, of course, has to be in a state of purity when it's mixed with the ashes of the red heifer. So they heard that these waters from two certain rivers are not fit for mixing with the ashes of the red heifer. Why? Because these rivers are not moving rivers, and this is swamp water. And so they erroneously thought, well, since this water is not fit for use as the water of purification, that means it is not considered water, and therefore it also does not render food susceptible to tumah. But it is not so. As there, with regard to the water of purification, we need, as it's spelled out in Numbers 19:17 in the Torah, running water. And water from swamps is not running water. But here, with regard to rendering food susceptible to impurity, any water renders food susceptible. It doesn't matter if it's running water or swamp water. So this was another mistake the Torah scholar knew, but the people misheard what he said. So it was taught at that time when Rebbe discovered the consequences resulting from a Torah scholar who was not precise with his terminology. The sages decreed a Torah scholar may not teach halacha, may not teach Jewish law, unless he receives permission from his teacher to do so. The teacher should not grant him this permission if he does not know how to express himself in a clear manner. So just the fact that somebody has a tremendous breadth and depth of Jewish law in his head doesn't mean that he's able to communicate that knowledge clearly to, crowds of people. That's a different skill. So you need somebody who both has the knowledge and the ability to communicate that knowledge. Now, it's not that he has to receive permission from the Nasi in order to teach, but he does have to receive permission from his teacher before he can go and teach others. And it's up to a teacher to evaluate whether the student has that communication skill in addition to the knowledge. Concerning a similar matter, the Gemara relates, Tanchum, the son of Rabbi Ami, arrived at a place called Chatar. And he taught them it is permitted to wash wheat in a small amount of water in order to make it easier to peel during the grinding process on Pesach, on Passover. And there is no concern that perhaps it will become leavened, it will become chametz, which is prohibited on Passover. Well, they said to him, isn't Rabbi Mani from Tyre here, i.e. near our location? And it is taught in a Baraisa that a Torah scholar may not teach halacha in the vicinity of his teacher, unless he is distant from that teacher by at least 3 parasangs, which is a long distance, corresponding to the size of the camp of Israel. In the encampment in the wilderness, no one else judged cases, as all the Jewish people brought their cases to Moses. See Exodus 33:7. So Tanchum, the son of Rabbi Ami, said to them, oh, it didn't even enter my mind that Rabbi Mani was in the vicinity. You're right, I would not teach anywhere in the vicinity where my teacher is teaching. I just didn't know he was in the vicinity. And the Gemara relates another incident. Rabbi Chiya saw a certain man standing in a cemetery, and he said to him, are you not the son of so-and-so, the priest? As it is prohibited for priests to come into contact with the dead. And Rabbi Chiya was surprised to see a priest standing in a cemetery. And the man said to him, yes, I am the son of a priest, but that man's father, meaning his own father, was a man with raised eyes, who would desire things he saw even if they were forbidden. And he set his eyes upon a divorced woman and married her despite the Torah's prohibition against such a union, and thereby disqualified the offspring of that union from the sanctity of priesthood. As the son of a priest who married a divorcee, this man had the status of a halal, and he was therefore not obligated to abide by the restrictions specific to priests because he was disqualified from serving as a priest. Interesting digression. I don't know why it's here, other than that we're talking about Rabbi Chiya. Continuing the discussion about receiving permission to teach halacha, the Gemara discusses the extent of this authority. It is obvious that one's teacher can grant partial permission, meaning permission to a student to become a teacher and to rule on certain types of cases but not others. As it has been said above, or to become a judge and to rule on certain kinds of cases and not others. As we just saw, that Rebbe said that Rav could rule on cases of monetary law but not on blemishes. So you can give partial permission. But what is the law with regard to granting such permission conditionally? In other words, is it possible to grant permission limited to a certain period of time or limited to a certain location? And the Gemara suggests, coming here, the solution to this question from what Rabbi Yochanan said to Rav Shemin. You have our permission to instruct and to adjudicate until you return to us. This statement proves that it is possible to grant permission limited to a specific period of time. Now, new subject, and I'm almost done, so questions or comments, please get them in now. Earlier, the Gemara discussed the possibility of a court consisting of only two judges adjudicating a case. Concerning the matter itself, Shmuel says, with regard to two judges, general rule is 3 judges are required to adjudicate a case. So what happens if 2 judges adjudicate a case? Do we say they're not 3, so whatever they did is meaningless, not a valid verdict? Or do we say they shouldn't have done it, but their verdict is a valid verdict after the fact? Let's see. So with regard to 2 judges who adjudicated a case, their judgment, this is according to Shmuel, with regard to 2 judges who adjudicated a case, their judgment is a valid judgment, but they are called an impudent court. Rav Nachman sat and said this law. Rava raised an objection to Rav Nachman from a Mishna that we're going to encounter on page 29a of this tractate. In a case where 3 judges are adjudicating a case, even if 2 judges deem the defendant exempt from payment, or 2 judges deem him liable to pay, and one of them says, I don't know, well, then the judges must add another judge, since the one who abstained has removed himself from the court. And now there are not a panel of 3. Now there's only 2 judges. And if it is so, as Shmuel says, that you can have a ruling by 2 judges, well, then they should be viewed as 2 judges who adjudicated the case, and there would be no need to bring in another judge, as judgment was passed by 2 judges. So since if one judge says, I don't know the law in this area, that they do have to find a 3rd judge, it must be that a ruling from 2 judges is not a valid judgment. Rav Nachman answered him, it is different there, as they convened from the outset with the knowledge that they are 3, and they intended to judge the case with 3 judges. Therefore, if one of them abstains because he doesn't know the law in this area, they must add another to complete the quorum. But here, where 2 judges came together initially to judge as a panel of 2, they did not convene with the knowledge that they are 3, but rather intended to adjudicate the case as a court of 2 judges. And per the opinion of Shmuel, they shouldn't have done it, but if they did, it's a valid judgment. Rava raised an objection to Rav Nachman from a Baraisa. Rabban Shimon ben Gamliel says, cases of monetary law are adjudicated by 3 judges, and mediation leading to compromise can be performed by 2 mediators. And therefore, the power of compromise is greater than the power of adjudication. As if 2 judges adjudicated a case, the litigants are able to withdraw from the case and demand a court with a complete quorum with 3 judges. But if 2 mediated a compromise, then the litigants may not withdraw. They have to accept that compromise and mediation. That's different than adjudication. And just at the very top of page 6a, where we'll finish, and if you would say the rabbis disagree with Rabban Shimon ben Gamliel with regard to a minimum number of judges necessary to adjudicate, but doesn't Rabbi Abahu say with regard to a court of 2 judges that adjudicated cases of monetary law of any type, which would include cases of admissions and loans, everyone agrees that their judgment is not a valid judgment, as a court with fewer than 3 judges is not valid. But the Gemara rejects this question. Are you setting the statement of one man against the statement of another man? Although Rabbi Abahu asserts that all agree that 2 judges cannot issue a binding judgment, Shmuel, the great sage Shmuel, differs. According to Shmuel, the rabbis hold that the judgment of 2 judges is considered binding. It's not their own opinions that they're referring to, but their understanding of what is the ruling that they have received from previous generations. And that's where we'll stop today. Let me take a few questions. Joe, how were judges approved for their positions? Was there a court where they proved that they were proficient? Sounds like, since they just went and asked Rebbe, they simply went to a sage that had enough authority, the Nasi or the Exilarch, and then maybe, now if the Nasi or the Exilarch was familiar with them, He could just say, okay, no, they are permitted. They have their necessary expertise. But maybe if the Nasi wasn't familiar with this judge, this prospective judge, either he might say, well, I don't know enough about him, and since I don't know enough about him, he does not have permission. Right? Or he might say, I don't know enough about him, tell me more. And then he could make that ruling. Right? But it was a very limited number. Now, today, right, very different. We said there is no one who has that level of authority who can, give someone permission to rule as a lone judge. You might say that two people can submit to the judgment of an expert rabbi, then that's much more like an arbitration. But when you talk about being compelled to appear, like someone is summoned to appear before a court, that's going to be a court of three, and that's a beis din. And, basically, in the rabbinic world, right, it's known who is qualified to serve on a beis din, and so it just wouldn't be called a beis din if it wasn't sufficiently expert. Joe, when serving as a judge, as part of a beis din, was there a certain area that they were assigned to serve within? I think you're talking about a geographical area. And as we've seen, yes. Jonathan, single judges. In some Hasidic communities, the head rabbi is accepted as an authority. You're talking about the Rebbe. Do they also accept his halakhic decrees like a single judge? If so, I wonder how far down it goes before a panel of three is required. Now, when we're talking about just telling people how to live, right? Like what's the halacha in ritual matters? Like that's basically established, right? It's all in the Shulchan Aruch. When new questions come up, because there's a new kind of oven or a new kind of, electronic appliance, someone is suggesting, here's a light switch with a timer, but it's not a timer, and it could be used on Shabbos or it can't be used on Shabbos, right? It gets very slippery because we don't have anyone at that level of authority as a Nasi or an Exilarch. So what we have is the Gedolim, right? The great rabbis of the generation who are sort of universally acknowledged, but even among them, they might disagree. And so somebody might come and say, here, this new light switch is approved by this great rabbi in Jerusalem, but, this great rabbi in Brooklyn or in, Tel Aviv or in Sfas says, I don't know, I'm not sure. And pretty quickly, that new light switch just will not be accepted and they won't be able to sell it in the frum world, right? In the observant, the Orthodox world, or the Haredi, the ultra-Orthodox world. And so it's more about sort of building consensus among the great rabbis of the generation in order to get a new ruling. But when people, just have a kind of a case of monetary law where they don't want to go to a secular court, they'd rather do it before a beis din. Okay, so then there are certain beis dins that are, very highly regarded, where somebody with a multi-million-dollar case, they're only going to go to the top level beis din. And then it's like an arbitration in the sense that the two parties are submitting to the authority of that beis din. So I hope that answers the question. And sometimes they don't need to go all the way to a beis din and travel, and they'll just submit their case to one of these gedolim, one of these great rabbis of the generation, and they're perfectly happy to accept his ruling. But again, it's because they're submitting to his authority. They're not going to be compelled to go before the authority of a single judge. Bill, I think I find the second explanation that Rav was too expert and the general public might make mistakes by extending his rulings improperly more believable than the first, to give honor to Rabbah. After all, if you were going to exclude a single matter of law so that his cousin could still get due honor, surely Rebbe wouldn't choose the field in which Rabbah was the accepted expert. Surely he would want one where they are comparable. I like that analysis, Bill. That makes sense to me. I think it really was this concern that he was too expert and people would make mistakes relying on his rulings, which is a really, a wonderful ability in Rebbe to, see into the future and see where unintended consequences could really lead the people astray. That was the tremendous wisdom of Rebbe. Lucy, How would a judge know that he had made a mistake? His ruling must have been questioned, but the plaintiff, though he might question, did not really have access to an appeal process that would make things right. Could the mistaken judge not just revoke his ruling and bring the matter before a court to re-examine the matter, rather than having to pay for his mistake? It's an interesting question. I don't know the answer. It sounds like, I could imagine the situation. He gave the ruling. They accepted his ruling. They went their merry way. Later, he was discussing this ruling with a fellow sage. And he said what he did, and the other guy says, yeah, I think you might have made a mistake. Are you not aware of this law and this nuance and this thing? And the guy goes, you're right. I did make a mistake. Okay, so now what? Does he need to go back and say, hey, guys, I made a mistake. Unwind the judgment. Let's start over. Or since I made a mistake, take it to another court. Or since they did accept his authority, they were accepting that he could make a mistake. There's no guarantee that he's going to get it right, but they accepted his authority, and then it just became binding in their case. Now, the question that, of course, this raises is, well, once he made that ruling in that case and people heard about it, then when the same case comes up in front of another court and the mistake is revealed, or now we're going to use the precedent, the mistaken case, as a precedent in all future cases. And that could cause problems, right? So then what? I don't know exactly how they dealt with that situation for this reason. But there is this tension between, look, they submitted to you, they accepted your ruling, it's done. However, but that's only if they accepted it. If they were compelled to come before you, then you have to make restitution and publicize the matter. And that's a different outcome, and for that reason. Two more questions. Yosef, the Art Scroll translates it that the people were kneading dough in kalim that were tameh. So the vessels were tameh, not that the people were tameh. Quite interesting. That the corn makes that difference. Wow. Either way, same issue, right? Either the person is tameh or the vessel that they're kneading it is tameh, but it will not be able to transmit the tumah to the dough unless it has come into contact with one of those 7 liquids. So the question remains, but interesting that the translation is different. That would reflect the difference between the staff at Art Scroll and Rav Steinsaltz in understanding what the incident was. Sharon, what's the difference between 2 consensus judges and 2 of 3? Seems like the difference is how they created the panel and what the expectation was at the outset, per what we read. And finally, Ilanit, these are turbulent times. AT Daily provides a warm and friendly connection to Torah, the nourishing light of the soul. Thank you. Thank you so much. That's beautiful. That's what I've got for today. And with God's help, we will be together again tomorrow at the regular Tuesday time, 6 p.m. Pacific. And my plan is to keep the schedule regular all week long, despite the fact that there are other holidays going on in America. My plan is just to keep our schedule regular this week. All the best, my holy sisters and brothers. Good evening.